Okay. So we are here today with Deeksha Sharma. Did I spell it right? I hope so. Okay, that's good. And with Adam Leckius. Deeksha Sharma is currently a student researcher and a contributor for the Path Check by Massachusetts Institute of Technology in the United States. She is the youngest person from India to get a fully paid fellowship to the Ansel Leadership Institute, University of San Diego. Also in the United States, and she has been invited for a TED-style talk with the Energy Innovation Network in the Silicon Valley, and her research on water footprint and international investment law was selected by the WWF International and African Network of Young Leaders for Peace and Sustainable Development. So you see that her curriculum is spectacular. And I'll give her the floor to talk about climate finance with a focus on loss and damage. Later, she will be followed by Adam Leckius, which I will introduce later. So the floor is yours, Deeksha.
Thank you so much. I'll just share my screen and then I'll start with my presentation.
Yeah, okay, it's fine.
Yeah, I hope it's visible.
Yes, we can see it.
Yeah. So thank you so much for this opportunity, and I hope all of you are doing well amidst these really challenging times. So my presentation here is about the drawbacks of climate finance or green finance, and I'd be actually analyzing it from a legal perspective because I'm from law background. So as you can clearly see on your screen right now, it's bankrupt and burning. So this is not related to bankruptcy law, but it's related to the drawback of green finance. Most of you must be aware of this company, Pacific Gas and Electric Company. It's a $1 billion company, a utility company in California, United States, and it's an American investor-owned utility, basically a type of private equity. Now, this business was involved in constructing transmission lines for power companies and basically providing a source, basically providing a network of transmission lines right from the source of power to the final consumer. And it basically owns around 80% to 85% of the transmission lines in Northern California. Now, how did this business suddenly go bankrupt? So the answers, as some of the scholars have suggested, is climate change. Now, what exactly happened was it all started with a spark in one of the in one of the transmission lines owned by this company. Now, the spark suddenly transformed into a wildfire, and some scholars have suggested that this was not because of the fault of the company, but because of climate change. Now, one thing needs to be noted is that the transmission lines owned by the company are around 70 to 80 years old. And the average age of a good line in California should be around 64 to 65 years old. And this was pointed to the company. And just 3 days before this incident happened, the company spokesperson tweeted that we would be shutting off business for around 2 to 3 days because we want to mend the lines. Now, most of these lines are also not, also vulnerable to fire because they are constructed near trees and very close to some of the big forests in California. Now, this small spark suddenly turned in a deadly fire, and it actually took away the entire town of Paradise in Northern California. So as you can see, this was the exact picture taken by media at the time Paradise was burning. Now, suddenly claimed bankruptcy under the Californian laws, and in 2018, and they're out of bankruptcy as of July 2020. What are the repercussions of this? Is that there's a provision of Chapter 11 bankruptcy in the Californian laws that allows you to claim money from the state and not pay the survivors. But as of December 2020, they've had an arrangement with the help of a law firm wherein they are providing some shares of the company to the survivors and also to the victims of the company. But it almost took them 3 years to get a good solution for the survivors. Now, why am I highlighting this particular company's example is because first, it's a big example where a bankruptcy was caused due to climate change. And also, it provides a good case study for highlighting the backdrops of climate finance. So now PG&E becomes a failure of a model that is of the private equity financed green infrastructure. Why? Because this company is highly rated by environmentally focused investors because they claim that they source all their energy from renewable sources. Now the drawback is that the data which is to be provided to these investors or to the analysts is self-declaratory, and it is not standardized, as in there's no standard formula or standard data that has to be maintained or to be given to the analysts for analyzing this entire company's environment focus. Also, green finance does not take into account the risks of the infrastructure already in place. Also, you might be knowing that some of the major dams, some of the wind farms and solar farms, they take up the area of an entire forest. And so, before installing any one of them, you actually have to clear out forests. I mean, I've seen a lot of examples in India, and there have been a lot of debates as to whether you could call this energy renewable because it is ultimately destroying the environment first and then acting on it. So it's basically starting from zero and going to, I don't know. Also, this Californian Public Utility Commission was of the perspective that because this company owns 80 to 85% of the infrastructure in Northern California, it has the consumers have to pay extra, so this utility could still provide power to them. So ultimately, we can come to the conclusion that the final cost of climate change and the cost of how these companies impact climate and how they pollute the climate is ultimately coming onto the final consumer, that is us. So it's basically green finance is that naughty pampered kid we keep forgetting mistakes of. Now, with the world drastically wanting to shift towards renewable energy, everyone is just talking about green finance with shares of renewable energy companies soaring high each day. So I've taken an example from Adani. Now, Adani Green's IPO came at rupees 100 in 2009. As of now, I checked last week, it is around 1034. It might be more. Uh, so exactly what I believe that green finance in the present scenario without any legal or regulation on it is not apt to actually deal with climate change. And also because green finance does not take into consideration the process of how the renewable energy is installed, or how what are the risks to the shareholders with that installation or the entire framework for providing renewable energy. So this was just one drawback for green finance, because green finance is increasingly being used for supply chain financing. So what I mean by supply chain financing is now international supply chains operate for providing goods from one place to another, and also for providing raw materials for some final products. So scientists and also analysts are actually researching how green finance and climate and supply chain finance management could actually collaborate to stop climate change, and also to make these supply chains, who are the biggest emitters of carbon, sustainable and environment friendly. But I really do not think that, seeing the current drawbacks of green finance, that green finance would be an apt solution to regulate international supply chains. And so, because I'm from a law background, what I really think could be a better solution to regulate international supply chains is the Convention on the International Sale of Goods. Now, this is a convention, or put simply, it's the international contract law. So, why it was made in the first place is that when supply chains operate on an international level, the complexities of law of each nation should be done away with. So we should have one uniform law to deal with the entire supply chain. So, for instance, if a product, if a raw material is first exported from Sri Lanka to India and then to the United States, so we do not want to take three jurisdictions' law into consideration. We just want one law, that is the Convention on the International Sale of Goods. But as of now, there are just 80 parties to this convention, and uh, two of the biggest jurisdictions, that is EU and US, are party, but again a lot of the nations are not. But I think they would be in the coming years, seeing the complexities of different nations contract laws. Now I would explain in a really simple way how this convention could solve the issue of international supply chain and sustainable management, which green finance as of now cannot. So these are the four clauses of the convention that I would be discussing in detail with you. But first, I'll just go with a case study here. So there was a consumer named Kasky who bought Nike sports shoes because he wanted that Nike feeling, and he was willing to pay the higher price in order to get that feeling. But this feeling consisted of Nike being an ethical company, because they had published a CSR policy on its website, which stated that they did not use child labor in the entire supply chain. But it turned out that Nike's sub suppliers used children in the production of Nike sports shoes. Kasky, even though he did not have any problem with the shoes, he sued Nike because that feeling was gone. Why did he pay the high price in the first place? So this was the very famous case of Kasky versus Nike, and Nike, after appeal, was charged with misleading information. Now, this case, I've used this case to show how feelings or emotions or ethical considerations form a part of a commercial contract between two parties. I mean, this is a very small example where a consumer was actually sad because Nike's feeling was gone, but there are cases where ethical consideration have formed a part of commercial contracts. I'll start with Article 9, that is trade usage. So, in a simple term, put in a simple phrase, trade usage is basically any kind of activity or any consideration that has been observed by the majority of traders involved in a particular field of trade. Now, how this trade usage becomes a part of a contract is when it is observed by a lot of traders in that particular field of trade, and it is ultimately made a part of the contract, even though the parties expressly did not mention that particular trade usage here. I'll give an example to make it simple. Now, for example, if I say the importance of trade usage is given by the American Federal District Court in the case of Geneva Pharmaceuticals versus Bar Labs, where it says that the usage and practices of the parties or that particular industry are automatically incorporated into the agreement, even though the parties do not expressly mention it, and unless they expressly exclude it from the contract. So an example here could be Novartis encompassing certain ethical standards such as animal welfare, child labor, and different environmental standards in its entire supply chain process. So this is an example of a trade usage that Novartis follows, and it expects all its suppliers to follow the same. And if they do not follow, there could be a valid claim made under Article 9 of this convention. Now, these are the two professors who are considered very influential in the interpretation of this convention. That is Professor Squenzer and Professor Peter. So both have agreed that if the company or any of the party has agreed to the United Nations Global Compact, so all the principles in that particular global compact are ultimately made part of the trade usage between the parties. So I'll tell you an example. So basically, United Nations Global Compact is a set of principles by the United Nations for businesses to follow. So this consists of not using child labor or actually obliging human rights in the entire supply chain process, and also environment protection. So as of now, around 8,500 companies are a part of this UN Global Compact. So any of the principles in the UN Global Compact are ultimately made a part of the trade usage between the parties, even though they explicitly do not mention it in the contract. I'll move on to the second article, that is Article 35 of the Convention. So, this basically says that any of the goods supplied by the supplier to the buyer should be of quality. Now, quality here does not necessarily signify physical attributes of the product or which are visible or maybe the functional use, but also what goes into making a product, as in child labor or environment protection. Those emotions that go into making a product are also a part of the quality of the product, but it's debated as of now, as a lot of scholars believe that it is not. Now if I give an example of Starbucks, now Starbucks boasts of its ethical supply chains in the procurement of coffee from its suppliers. Now, in just in case any of its suppliers is found using child labor or violating human rights in the supply chain process, Starbucks has a valid claim under Article 35 of the Convention to sue its suppliers for harming its reputation, like for example in the case of Nike. Now, what are the problems for this particular thing is that the German Supreme Court in the New Zealand mussels case established that the supplier cannot be expected to be informed about special requirements in the state which the goods would be used, or the state uh, where the buyer currently resides, or where the buyer wants the goods to be delivered. Now, this is a big problem for this particular article, because I believe that the German Supreme Court has established a bad precedent in law, and I'll show you in the next slide why. So, the preamble to the CISG states that it is established to fulfill the objectives of the new international economic order, basically unification of the entire international economic law. Now, there's an Article 7 in the convention, which is something sort of a interpretation or used for interpretation of the convention. So this particular article says that this entire convention has to be interpreted keeping into consideration its international character, and that it was made for the unification of international trade law. Now, this convention, put simply, was made to fill in the gaps left by international trade law. Now, a convention that is made to fill in the gaps of international trade law has to follow some of the principles established by international trade law. And so, using the interpretation rules as set by the Vienna Convention on the Law of Treaties. Now, Vienna Convention is basically an international convention which has some set of rules which is used to interpret international conventions or treaties. Now, one of the articles of this convention says that a treaty should be interpreted in good faith in accordance with its object and purpose. And like I previously mentioned, the object and purpose of this particular convention on the international sale of goods is to fill in the gaps left by international trade law, and hence it has to follow the principles established by international trade law. Now, understand, international trade law has this relevance of this issue with the help of process and production methods. Now, as you can clearly decipher from this particular phrase, process and production methods are used, basically the methods of production used for any particular product. Now, they are divided into two parts: non-product related process and production methods and product related process and production methods. Non-product related, as the name suggests, are those methods of production which have no bearing howsoever on the physical attributes of the product. So any attribute that is visible is not covered in the non-product related process and production methods. And in product related process and production methods, the methods of production that have a bearing on the physical attributes of a product. So if I give an example to make this easy, is that there are two apples. You go to a supermarket to buy apples. You see two apples on the face of it. They're both red, and you cannot clearly decipher any difference. You cannot decipher the two apples on the basis of the physical attributes. They are red, they are fresh, they are organic. But if you come to know that one of these apples was made using less amount of water, or was made in a sustainable way, and the other apple used a lot of amount of water and was not made in a sustainable way. This is the difference that I'm talking about, the environmental difference between two goods. Now, there are a lot of cases in the WTO which give way to such kind of differentiation between two products. So, if international trade law allows such a differentiation between two products, then CISG's Article 35 essentially has to um, include such a differentiation in these two products. I just explained this entire slide. Now, there is this important case of shrimp turtle with the World Trade Organization, in which the World Trade Organization actually uh, interpreted that different techniques used by different countries while harvesting shrimp, they formed a part of PPM and hence a determinant of likeness between products. Basically, how different countries harvested shrimp could be a basis of how we decipher two products. So this same principle has to be used in the CISG also, which the German Supreme Court is currently ignoring. As in, the supplier has to be aware of what are the laws of the buyer so that he has to fulfill that. Now, last topic of my presentation is sustainability contract clauses. These are the clauses which say that both the supplier and the buyer have to follow certain sustainable standards in their contract, or the supplier has to follow a sustainable supply chain while producing goods. These clauses are very rare, and only some of the companies, just to maintain their reputation in the market, for example, Nike and Starbucks, just to name a few, use such kind of clauses for their suppliers. Now, these clauses, again, it depends upon the party's intention and the drafting of that particular clause. Now, another question that arises from these clauses is whether, if you're breaching a sustainability contract clause, would it amount to fundamental breach of contract? As in, would the buyer then be liable? I mean, would the buyer then have the right to make the seller liable for breaching the contract in its entirety and not just a particular angle, because that particular point which the supplier has breached forms an essential part of the contract for the buyer. So, if I give an example of Starbucks, for instance, here, if any of its suppliers use child labor in their procurement of coffee, then Starbucks can say that this particular obligation of the supplier to not use child labor formed a fundamental breach of the contract, because now the reputation of Starbucks is on the quality of the coffee it provides to the customers and also the ethical supply chain. And that is why we are giving extra money for procuring coffee. So Starbucks can use this particular um, clause in the contract. Now, my presentation, I'm just ending my presentation here with the conclusion that I really do not think that green finance in its present state can help solve the climate crisis, and we would actually need help from commercial and economic aspects of law coupled with green finance to regulate supply chains and also to regulate green finance too. Thank you so much.
So, okay, here I am. Thank you really much, Deeksha, and the presentation was really detailed and really much appreciated. Really, thank you. I will now briefly introduce Adam and leave him the floor. So Adam is a bachelor student in PPA at the Lund University in Sweden. As the international coordinator of Push Sweden, he led its delegation to COP23 in November. And that was his third round at the UN climate negotiations. In that function, he also had the pleasure of getting to know at least part of the EU environment through collaborating with the Climate Action Network Europe. So I will give the floor to you, Adam, and I guess that you will cover more the loss and damage part, given the fact that you attended the COP negotiations. So the floor is yours.
Thank you very much. Yeah. Okay. Well, first of all, I can say that indeed I am now working at Climate Action Network Europe as well, the secretariat, and I can say that if maybe everyone doesn't know what CAN Europe is, it's a network of NGOs working on climate change throughout Europe, and Climate Action Network is an international organization. Just to be clear on that. And that being said, first of all, I have to leave at 5:30, so I'll be very. I think I will have to be very brief since not a lot of time, and if anyone has any question by any chance. But yeah, so as you said, I've also been working with the UN negotiations in the UNFCCC, the UN climate change body. And there, indeed, I had a focus on climate finance. So the title of this call now, climate finance, what is it? And specifically loss and damage, I have come into contact with at these UN conferences and the work related to it. So for me, I mean, we had it was an interesting presentation, a lot of things that I cannot comment on from Deeksha just now, but I got from that in terms of green finance, that was mostly about private finance, private investments, and climate finance for me, just to say from the basics, of course, with the problem of climate change, we need, if we're going to solve it, we will need a ton of money, an extreme amount of money we will need in order to solve it. There are different calculations. 90 trillion is one number that has been used up until 2030. That's what we will need. So in dollars, that is a huge amount. So we need all sources of finance, possibly, just to say that, we need all financial flows going around the world to be directed to good purposes. And again, we just had a detailed reflection on what good purposes are and how that should be regulated. But that's kind of the overarching picture. We need a lot of money. And then for me, climate finance has usually, and I think that is maybe how that term is usually used, is when you talk about public finance, development finance, basically aid money coming from developed countries. I'm just taking from the basics here, just to be sure. Taking it from developed countries to developing countries. And that is a fundamental part of the Paris Agreement, and part of the UN work on climate change and the UNFCCC, the UN Convention on Climate Change. And so that is really at the heart of the international climate change politics as well, and the negotiations, because the Paris Agreement specifically says that developed countries have a responsibility to provide finance, climate finance, which again is usually public finance, to developing countries. But that's, as you can imagine, often something that can be a source of conflict. Now, that is a key priority for us. We work in the EU. Now I'm speaking of CAN Europe. We work in the EU to put pressure on European countries to do this, to pledge to the world that they will provide this finance, to developing countries, in order for those developing countries to be able to also raise their ambition in terms of reducing emissions, reducing greenhouse gas emissions. So in order for them to do that, they are entitled by the Paris Agreement to financial support. So that is what climate finance usually means to me, very, very briefly. And of course, that will be increasingly as well a conflict, and I'm speaking still about generally climate finance, increasingly difficult now with Corona, with COVID, with all countries struggling financially, economically. Especially, I mean, the European countries have been hard hit, of course, by COVID. So it might be hard for them to convince even good governments that want to do this, want to support developing countries in terms of climate finance. It might be hard for them to convince their populations that this is something in the age of Corona that they should spend money on. But we try to push them to do so. But we will see how that goes. So of course there is a lot of things to say about climate finance, but then there are different types of climate finance. And this is to transition to say a few words about loss and damage. But climate finance can take many different forms. As I mentioned, one form is to support developing countries with finance so that they can decrease their emissions, which is called mitigation of climate change. That is one form. And then of course there is the big funding needed for adaptation, how to adapt to the climate impacts that will have, that we are seeing already, and that in some developing countries are very severe. So that is one important part of climate finance, which we're also pushing for getting attention by contributing countries, the rich countries. And then, so those are the two big ones. And then there is this other form of climate finance, which is called loss and damage. Now, again, I will say a few words on a basic level, but just that this was part of the Paris Agreement as well in 2015. It was a priority for some developing countries, especially, and loss and damage finance is important to them because it's a kind of finance that compensates for the impacts that cannot be adapted to or reversed. So in different, that's different from kind of adaptation finance, something that you can adapt to. For example, just we will have sea level rise throughout this century. How high will the sea rise? Will it be enough so that you can adapt to it by building kind of walls or what is it called in English again? Building some kind of device to stop the water from flooding the shores, or will the sea level rise that much so that for low-lying islands it will mean an existential risk of the islands actually sinking in part or altogether? And in the latter case, that is of course extremely tragical for the populations on those islands, and it is one kind of area where we would talk about loss and damage finance. So this is finance that compensates these people for the impacts that they cannot save themselves from. For example, they might have to evacuate, which would cost a lot of money, apart from just a horrible experience of doing that. So in that sense, it's kind of the ultimate climate justice, because I think of climate finance a lot as an example of climate justice, where developed countries, rich countries, have been able to develop their economies through emitting a lot of carbon dioxide and greenhouse gases, and then the impacts are falling most harshly and severely on developing countries, poor countries that are very vulnerable as well to climate change. And again, this is a crucial question, crucial issue, especially for countries like small island developing states that have been pushing this in the international negotiations. So it's been a point of conflict, because it's a hard thing to sell for rich countries, demanding of them that they should provide this money, because it's hard to say what can be defined as loss and damage finance, what should be defined as impacts that you cannot adapt to. That is a discussion that is quite complex. Won't say anything in detail about that, but it's been hard to demand that of contributor countries, the developed countries. But we are still pushing and developing how to look at loss and damage in order to make it more salient, more easy for rich countries to accept this. And some countries are already trying to do so. So there's a lot of things that need to be done on that. We need a kind of definition of what loss and damage is, working definition. We need to know about what the needs are within that definition. And we need to think creatively about what kind of finance we can use for this. Maybe it's not just, as I said, that's hard to get public finance through from governments. Maybe there are other kinds of sources that we can find. For example, taxing the fossil fuel industry, taxing international aviation, taxing financial transactions, etc. These are obviously hard projects to go about, but it's kind of examples of the creative thinking that we need to do in terms of how we should find money for loss and damage in the future. I think, yeah, okay, so we're nearly done. I tried to keep it brief, 10 minutes, but yeah, if there's any question.
Yeah, I don't know if there are any questions from who's listening to us, but I have a few for you, Adam, and for Deeksha. I will start from you, as you have to go away. So I will focus on the last COP25. And you probably saw the, I don't know if you followed the negotiations regarding loss and damage. And if yes, you probably noticed that the United States actually took hostage all the negotiations for more or less the whole time of these negotiations. And actually, more or less nothing has been obtained at the end of COP25 in matter of loss and damage. What do you think about these United States blocking everything and also pushing for actually not paying for the damages that partly they also caused? So this is the first question, but I think an answer is probably to be seen regarding the Trump administration. So I want you also to ask, what do you think about the European Union, where, for example, me and you live, and the European Union that so much talks about environmental policies and green policies, while actually standing with partly on some issues with the United States during these negotiations that happened at COP25. So these are mainly the two issues: the United States and Europe.
Yeah. Thanks. Indeed, it was interesting. I was there in Madrid end of last year, and I did follow it in some detail, not at the most detailed level. But yeah, it was it was, of course, I mean, I could say that it's been, of course, sad to see the US generally these last couple of years under Trump. Of course, they are, and him having said that they will exit the Paris Agreement, now they will rejoin again with Biden, so that's a very good thing. But yeah, in terms of climate finance generally, not just loss and damage, but of course they have been very clear that they are not going to acknowledge their responsibility, much less actually provide climate finance in any way. And that's of course just a disgrace. The responsibility of the United States especially is tremendous, to use one of Trump's favorite words. So that especially, you mentioned the concrete moment there. I mean, yeah, that did happen. They took the negotiations hostage. You could say that. I mean, their position is well known, and this has been an issue that has been stuck for years, I have to say, and that is unfortunate, but it has to do with these difficult things that need to be sorted out. For example, the definition of what constitutes loss and damage finance, and the problem is that they indeed have not been willing to help forwarding that process or making it actually develop in a good and productive way. So that's definitely on the United States, and let's see what happens at the next COP and in the next year with Biden. There might be change, although loss and damage will still be very hard for the US to accept. And also going on to the EU, I mean, I have to be also pragmatic. While we are really advocating for loss and damage finance, we have to acknowledge that it is difficult. So we also, from civil society, from NGOs, need to contribute and do our work in kind of finding new sources of finance, as I said. And for the EU, they have not. I should say some EU member states are more ambitious. My country of Sweden, they have for a number of years said that they are in alliance with these small island developing states, and they want to push this forward. But we will see what happens with the EU at the next COP, I guess. I think time has run out.
Yeah, okay. Thank you, Adam. You're free to go now. And I want to end on your question by remembering that during last COP25, I remember the group of the small island states explicitly stating that they are at an existential risk for what's happening. And so countries that contributed more should at least take full responsibility of what they did historically and help those countries. So I want to add this small detail. Then now, bye, Adam. Thank you. I also have a final question for you, Deeksha. And then so I think your presentation was really detailed, so I didn't really know where to start to ask you something. But on the part of what said Adam regarding public and so on the other hand private sector finance, you think that, for example, with this program, which now sees only 18 country members, that the private sector could push more for sustainable demands, for sustainable targets and baselines, given the fact that more and more industries and different partners would join if countries joined. So I will restate my question. I mean, do you think that private sector could push more for ambition and sustainability if countries joined the program you previously described?
Yeah, thank you so much for the question. I believe at this particular moment, public law would not be able to help as much as the private law could, because private law comes with a check on corporations. See, I wouldn't really say that corporations would want to enter into such a scenario where there are checks on their supply chain, on the sustainability standards or environmental standards, because obviously that would lead to lowering the profits of these corporations. But I really believe that once more countries, see, as of now, 80 countries are a part of this convention, and once more countries start entering this convention, automatically the corporations would be liable to have to follow this convention. So I believe that at this moment, we need to look for solutions in commercial and economic law rather than, going with international environmental law or climate change law to help solve the climate change crisis.
Yeah, thank you. That was clear enough and really brief. So I want to thank you again for being here. Okay.